Mr. Dushane, if you could please mute yourself until your hearing is called.
Yes, are the parties on that matter present? Please unmute and state your name.
Yes, hi, my name is Irish Nolasco, and I'm present.
All right, ma'am, I haven't quite gotten to your case yet, so you can go ahead and mute. Or, yes, mute yourself. All right, so it appears neither party is present then on the Milne versus Gow matter. Front of the court, what is the status of this matter?
Your Honor, this hearing was adjourned from Judge Mertz on October 7th, when the defendant failed to appear, but bond was forfeited to the friend of the court. Since that hearing, a new uniform child support order entered with a change in support from $100 to $669, and the balance on the account is $3,612.24 after the bond was released. We do not have an address for the defendant, a good address as of right now.
Is he, as far as you know, at least a resident of Michigan?
To my knowledge, yes.
Okay. And what is his current, I'm sorry, I missed the balance.
Yep, the balance is $3,612.24.
Thank you. Given his failure to appear, I will recommend a bench warrant in the amount of $950 plus $100 in costs. Not appear that either party is present, as no one has unmuted to identify themselves. What is the status of this matter?
The defendant was arrested on September.
Hold on, sorry. Is that Mr. Briggs?
Yes, sir.
All right, thank you. All right, for the court, sorry about that. Can you proceed?
Yes, the defendant was arrested on September 30th on a bench warrant for failure to appear at a hearing on January 19th of 2022. The defendant had contact with a friend of the court on September 27th and reported an employer. The defendant stipulated to make a $200 payment within 2 weeks of release and appear today in front of your honor. Since his release, October 4th, the defendant reported he no longer had the job that he previously had reported before his arrest. The $200 payment was received on October 11th. On October 29th, he updated our office that he was in Ohio looking for employment. The defendant's support obligation is $342 and has a balance of $23,013.56. Prior to the recent payment, a $40 payment was received in May of 2022.
Thank you. Mr. Briggs, what would you like to say regarding this matter?
Well, I'm still trying to find work, and I just, I have a hard time finding work. I'm an ex-convict, and that's been a conflicting issue.
All right. Are you living in Ohio or are you living in Michigan?
No, I'm at the address stated in Lansing. I was just desperate for work. I thought I had an opportunity down there, so I went down there just to look for work.
All right. When was the last time that you worked?
At Ryder, when I got arrested.
All right. So back in September was the last time you worked?
Yeah.
All right. You've had no employment since that time and no income?
No, sir.
Do you rent a place, own a place, live with somebody?
I'm staying with somebody.
How do you support yourself at this time?
I other than a bridge card, sir, I don't have no kind of employment. I'm getting kicked out of here soon because I can't afford to pay rent anymore because I lost my job. So.
Okay. And then it looks like you went quite a while without any payments. Is that correct?
Yeah, I hadn't been working. I got a lot of physical injuries.
A couple of years where you weren't really making regular payments. Are you saying you weren't working that entire time?
No, I wasn't. I'm trying to sign up for Social Security. I got a lot of physical impairments and stuff, but I needed money, so I just went back to work trying to instead of trying to sign up for Social Security.
What do you feel prevents you from working?
Well, I got physical impairments. You know, I got arthritis from my ankles to my neck and old injuries, and it's been hard. Like I said, I have been fired from jobs as soon as they find out I'm an ex-convict. Yeah. And that's partly why I'm not a part of my son's life. I don't ever see my son. She don't want me to see my son. So.
All right, well, based on the information provided, I am going to recommend a finding of contempt. Just hasn't been that effort, sir, to make payments. So I am going to recommend a finding of contempt, as I do believe, well, there is clearly an arrears in this matter, and I'm satisfied that you have the capacity to make some type of payment and have failed to do so, that you have not exercised diligence in trying to pay all or some portion of this matter. You have not made a good faith effort to pay. Set your matter January 6th before Judge Mertz. It'll be at 9 a.m. and you will get a notice for that. I would indicate that if you do make a payment of $2,500 prior to that date, then the show cause, the contempt hearing would be removed. Do you have any questions, sir?
No, sir.
All right, thank you for appearing today. You're all set.
Neither of those parties has appeared here in court today. Ms. Kraus, can you tell me the status of that file?
On November 20th, the referee recommended contempt. He had indicated, based on his testimony, he has not made a diligent effort to pay all or some portion of the amount due. He has the capacity to make payments. The defendant had not made good faith efforts to make payments. A purge payment was identified that could be made of $2,500 to dismiss that. The payment was not made. The monthly obligation is $342. The total owed is $23,718.56.
Okay, based on Mr. Briggs' failure to appear, the court will issue a bench warrant with that same purge amount, and we'll proceed further once Mr. Briggs is arrested and brought before the court.
So $2,500, correct?
Correct.
Okay.
Yes.
Yes, we have the parties on that matter present.
I'm in here.
The parties are present. In front of the court, what is the status of this matter?
The defendant's support obligation is $156 and a balance of $6,962.06. The defendant has 6 cases in total, 4 that are currently charging to collect $592 and 2 cases that are arrears only, with a total balance for all cases of $37,036.97. There's been no payments received for this case since April of 2024 in the amount of $168.80, but there have been specific payments made on another case as recent as October. The defendant reported he was working as a 1099 employee in July, indicating that he had been working 38 hours weekly for at least 3 weeks. He has made payments in July, August, and September with specific payment requests to other cases, but has not met his obligation for any of the cases since December of 2023 from a prior income withholding. The parties together did present at the friend of the court. The plaintiff submitted an arrears forgiveness request to the friend of the court. Our office has not had an opportunity to review the paperwork.
Thank you. Mr. Higley, what would you like to say?
It's true. Been between jobs, and then in July I got gainful employment. Never said anything about working all 38 plus, especially with it being wintertime doing construction as a roofer. I'm lucky if I'll get 20 during the winter hours. Yes, I have been making other payments, and I was bouncing back and forth between, like, 1 week I'd pay on 2 cases, next week I'd pay on another 2 cases. Things got rough. Vehicle wise, getting back and forth between jobs. So I've always tried to pay something somewhere. Me and Miss Mager haven't always seen eye to eye, and finally we sat down the other day and had a conversation, and she agreed to forgive the arrears as long as my current monthlies stay up to date. So that's the route we took. I'm actually surprised she's not in here because she said she was coming, but
I am here, Your Honor.
no.
Yep.
But I mean, other than that, yeah, things have been hard for me. So just trying to get my things straight again and move forward. That's it.
Miss Major, what would you like to say?
Joshua's correct. I did agree to take the arrears away. I want Joshua to realize that he has obligations here. He's on his 8th child. He has 2 with me, but I don't want to set him up for failure. So, I did sign a paperwork yesterday to forgive everything but this month. And I mean, that's where we're at, Your Honor.
Okay. All right. Would you please raise your right hand, Miss Major? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right. So, Miss Major, it's accurate that you are asking forgiveness for the arrears owed to you in this matter. As to what date? Looks like on this form you said 11/19/24. Is that correct?
Yep. Everything but the current month that we are in, Your Honor, is what I had discussed with the caseworker.
Want the November payment, correct?
Yes, yes.
You would forgive the arrears through October of 2024. Are you making this decision freely and voluntarily?
Yes, Your Honor.
Do you have any questions regarding your decision?
No, I don't. I actually do. Is there, the support is set at a too high amount for Mr. Higley to fulfill those obligations. So I don't know if we can lower, if I can sign something to lower or what we can do, but the amount unfortunately isn't realistic for Mr. Higley.
You'd have to file a motion to change the support amount.
Okay.
And then potentially a new review could be done to see what the appropriate amount would be.
Okay, well, thank you.
But until that time, so Mr. Higley, that amount does remain your amount. And obviously you've just been granted some grace and the forgiveness of a very large amount of money. So we would expect you to be staying on top of your monthly payments.
Right.
So I will, based on then the statements from Ms. Major, indicate that the arrears would be forgiven that is owed to her through October of 2024. Any questions from front of the court?
No.
Would we then dismissing this or adjourning it out to monitor payments?
I think I would just dismiss it, and then obviously if it gets behind a couple months, then we should set that up right away.
All right, thank you.
Thank you. Mr. Higley, any questions?
No, Your Honor.
Ms. Major, any questions?
No, Your Honor.
There you go.
All right. Thank you both for appearing. You're all set.
Thank you.
Huh?
Friend of the court.
We have the parties on that matter present.
Here, Your Honor.
I'm also here, Your Honor.
All right, thank you. We do have both parties present. Front of the court, what is the status of this matter?
This hearing was adjourned from September 18th to monitor consistent payments from the defendant. The defendant has a support obligation of $513 and an account balance of $20,976.21. Since the hearing, the pending $300 payment dispersed and $223.05 was applied to this case, but no additional payments have been made.
Thank you. Mr. Dushane, what would you like to say?
Your Honor, last month, I made an $1,800 payment to the friend of the court in Gaylord, Michigan. I believe it all went to my other case. I'm currently fighting another case that is in the circuit court, and I'm on my I'm on the cusp of having a 1 year delay while I make payments, but I have to make up to a $5,000 payments before January. So I did pay $1,800 last month. I could show you a receipt, but I did send that, but my attorney has that information as well for my other case. So it's not like I'm not making payments. I didn't make a payment on this case, but I also read when I went to make that payment to the court, it says in the friend of the court information that you could, because I wanted all my money to go to that case, but it says that the money by law goes to the state disbursement. So I don't know if any of that 1,800 was applied to this case. I do not believe that it was. My attorney wanted me to try to get it all applied to another case, but just so the court is aware, I am currently making payments in circuit court, district court, in multiple child support cases now. Not that this is unimportant, but I'm kind of burning the candle at both ends and trying to fight to stay out of jail in more than one front. So it's not for lack of effort. And if I could get a small adjournment, I could make a payment on this case, but not until the beginning of December. But in the past 60 days, I had made over $2,000 in payments to the child support for my arrearages.
All right, anything else you want to say, sir?
I don't believe so, Your Honor.
Thank you. Ms. Delasco, anything that you would like to say?
That's right. The last time that anything came in for the child support was on September this year.
Okay. Anything else, ma'am?
And I've only received maybe a couple of months worth of child support, and it's not the same, amount all the time. So it's been many years that he hasn't paid anything. He's missed a lot of months of no child support. I think he's only paid 2 months this year.
I spent a good amount of this year in jail. Not a good amount, but I spent the summer in jail.
So the front of the court, his most recent payment on this case was about $220 some dollars. Is
In
that correct?
September, prior to that was July of $233.04.
I was in jail until July. I got out July 10th.
And that other payment he mentioned, then that went to a different case. Is that correct? As far as you know, nothing came in on this case.
Correct.
Okay.
Yeah, I can't verify it in regards to the other payment, but if that's the case, then that's quite possible.
I can show you a receipt if you'd like to see one.
Well, I'm not going to dispute that you made that payment, but obviously that wasn't a payment on this case, which is part of the issue. Anything else you want to say, Mr. Dushane?
No, sir.
All right. Well, I'm going to recommend a finding of contempt. It is clear that in this case there is an arrears. The balance is now exceeded $20,000. There was a payment made. It appears since September, only one payment made on this case, the amount of around $223. Mr. Dushane did indicate he did make a payment on another case, but while it is good to make payments on other cases, it does not give you credit for this case. And it does show that he did have the ability to make some additional payment on this matter out of his resources and failed to do so. And not exercised a diligence in paying this matter and has not acted in good faith in making payments on this matter. So I would set the matter before Judge Mertz on January 6th at 9 a.m. I would indicate that if you do make a payment of $2,500 prior to that court date, that hearing date would be removed. All right. Thank you both for appearing. That does conclude the matter. Thank you.
Thank you. Thank you.
Ms. Kraus, can you tell me the status of this file this morning?
The referee's hearing on November 20th, the referee did recommend contempt. Based on his testimony, the defendant has a balance exceeding $20,000. He has the ability to pay out of currently available resources, and he has recently made a payment on another domestic relations case. He has not made diligent effort to pay all or more significant portion of the amount owed. He was given the option to make a purge payment before today's hearing in the amount of $2,500. This morning, Sean did present at front of the court to make a $1,000 payment. He has also, in the meantime, requested a review of support. With that review, he submitted limited information, so it would be beneficial for friend of the court to have some more information on how to go about the support recommendation for his income.
Okay. All right. Ms. Nolasco, was there anything you wanted to say in this matter?
I know the last time we were in court is that it's, the 2,400, and then he hasn't had any kind of payment at all before that. I understand that he had some kind of circumstances. So right now I'm just trying to see what we can do about this.
Okay. All right, Mr. Dushane, so the court is going to set this over for 30 days. Although, you didn't make the $2,500 payment, you did make a $1,000 payment. So the court is going to set this over for 30 days, and the court will make a determination as to the contempt at that time. Ms. Kraus, does he need to contact friend of the court regarding the additional information, or is that something that you can state for the record here today?
If I could state for the record, the questionnaire that he did submit had a lot of information blank. This morning, he did submit some information from like 2019 through the present, which he had indicated on Friday that he hadn't had any income. But today on the paperwork, he said he completed a flooring job that he received $2,000 for. So I'm looking for his income amount to input for that calculation to get it out.
Okay. Mr. Dushane, can you address that for us?
I'm not sure which part, Your Honor. I'm sorry. I was listening, but I'm not sure what exact part you want me to address.
Can you provide that?
Income.
Yeah, can you provide that information to the friend of the court?
I did this morning. I wrote some stuff down on a paper. I could go over it again if you want, but so as of November 19th, or as of November 9th of this year, I broke up with my girlfriend that I was living with, and now she is keeping all of my stuff, and I am suing her. We go to court next Monday. So as of November 9th, almost 60 days ago, all of my tools were taken from me, and I can't even work. So I was just able to complete a flooring job with the help of some other guy and his tools. I made $2,000 and I turned over 1,000 of it this morning. I just got that money on Saturday. So when I talked to Ms. Kraus on Friday, I did not have that money. So I didn't count eggs that weren't hatched, I guess, Your Honor. And then this morning I paid half of the money that I received.
So Ms. Kraus is indicating that you left a lot of information blank on that form that you turned in. And then Ms. Kraus, again, for the record, can you state exactly the most important information that you need from him?
His gross income monthly, so we can do the recommendation.
So, okay. Mr. Dushane, you need to provide that in writing to the friend of the court. Otherwise, nothing's going to get adjusted. You won't even be able to have it considered. Okay.
Yes, sir. Can I say one thing that I would like to be on the record, please?
Yeah.
So obviously I knew that I had a son and that I wasn't paying child support, but I had never gotten any information. In 2020, I received any information when this child support stuff started. I didn't know anything about owing child support obligation until less than a year ago. But in 2020, I was working a job making $14 an hour, paying child support for 2 children right here in Gaylord. So what I don't understand, I can't seem to calculate it in my head how this number was ever even brought up. My obligation for my son here in Gaylord is $179 a month. Then, so how does the next kid, the third kid, be triple? On top of that, I'm only making $14 an hour. So I feel like the $20,000 number is inaccurate. And so I don't feel like it was calculated correctly because I don't believe it was based on $14 an hour at the time of the case. So I feel like I owe more than I should. And it seems unfair, I guess. And I don't know how better to explain it. But I do believe I owe money. I'm not stating I don't. Oh, I know I owe.
Well, if you want to challenge the amount, there are ways to do that. You just telling me that here on the record, is not going to be sufficient. You need to challenge the amount. You're going to need to file a motion in the front of the court. You may need to get an attorney to help you with that. But if you want to challenge things going all the way back to 2020, you're going to have to do a lot more than just make a statement like this here on the record, because I have no idea, based on what you're telling me, whether it's appropriate or not. So that's something that you need to be proactive about, because based on the information that we have, and the court has followed the law in terms of what it needs to charge based on the information that was provided to us. So if you think that's wrong, or you weren't provided appropriate notices or so forth, then you need to be proactive about that, start filing some motions to get things changed. Otherwise, it's not going to change. And just saying it on the record is not sufficient.
I did file a motion. I did file a motion regarding support. That's in the works right now. I got another one this morning when I was at their office. I will be more proactive, and I apologize for not being more proactive.
Yeah. So, if there was something wrong, we'll look at it based on what you file. And obviously, if there's a mistake made, we'll correct it. But if there's not, then we're going to go forward. So either way, you need to provide the information that Ms. Krause has indicated within the next 30 days. Can you make another payment within the next 30 days?
I'm not sure because I'm fighting another child support case this week that also needs to be addressed. So I don't know for sure, but I will definitely try. If all of my personal property wasn't being held by my ex-girlfriend, I could sell my personal property and make payments. So I'm kind of screwed in the sense that my ex is being spiteful and holding all of my stuff. So I can't even sell my assets to even try to make any payments on because I have nothing right now, which sucks. And that court case is on Monday. I'm suing her for $7,000 because she has all of my tools. I've been a flooring guy for 20 years. I'm a felon. I can't go get a job at just most places. So I've been doing my own little flooring gig for a long time. And now I just can't do it because all my stuff's gone.
Ms. Krause, is there a monthly amount still charging on this?
$513.
$513. Okay. All right. So the court's going to order, number one, that you provide that information within the next 30 days. The court's going to order that you make a monthly payment within the next 30 days. We'll set this for hearing at that time. If neither or either of those things is not done by that hearing, then the court will proceed with contempt sanctions, and we'll go from there. Ms. Krause, anything else we need to address on this file today?
No, thank you.
All right. Thank you. Both parties are free to.
I have a question.
Yeah.
Hi. We did all the paperwork. If you can go all the way back to the 2020, it was actually because of COVID, it was pushed back. So I believe that, everything that he gave, I have the paperwork that he put, how much he makes and everything like that. And I understand that there's the two other kids that he has to take care of. I understand that fully. Obviously, that's something that he has to take care of, but he also has our child that he has to take care of. And I feel like that amount that he's contesting is actually the right amount for it. It's actually less because it got pushed with the COVID. My case was not heard for like pretty much 2 years, I believe so. And he hasn't paid anything. And we, everything that all the question that, all the paperwork that the court asked me to do, I gave everything that I have. And I haven't even done any kind of, it's been my son is 10 years old now. The last time I did the very first time, he was 3 or 4. So his actual amount is actually more than what he needs now. He needs more. It's just I'm not even doing that. And that's why I don't know, like, if this does not, 30 days from now, if it doesn't go, do I get any kind of paperwork that we are doing another hearing?
Yes, you'll be notified of that next hearing, and you'll be able to appear as you have today. And, my point to Mr. Dushane is, as far as the court's concerned, the amounts are correct and everything's been done correctly. If he can bring forward some kind of evidence through his motion that it hasn't, then we'll have to take a look at that. But as it stands right now, it's not going to change unless, the burden's on him to come forward and show that something has been done wrong or calculated incorrectly.
Yes, Your Honor. And then also the, what is it called? The amount for the next 30 days, is it just the rest of the 24 or 2,500 that he owes on contempt?
Right now, the court's requiring him to make the normal monthly payment and provide the information. If he doesn't do that, then the court will proceed with contempt.
So it's the regular monthly payment that he owes.
Right. What I'm trying to do right now, Ms. Nolasco, is keep some money flowing to you. If that doesn't happen, then at that point, again, we'll proceed with contempt and the court will likely order jail time for Mr. Dushane. What I'm trying to do is just keep some amounts flowing to you.
Okay.
And, you know, because that's going to do you more good than him staying
Yes, sir.
being in jail. But if he doesn't pay,
Yeah, I
then
understand.
if he's not paying, then there's no reason not to put him in jail. So the
Yes,
idea
sir.
here is,
Yeah, I understand.
yeah, okay,
Yes, okay.
all right.
Okay, and then also that the 1,000 that he pays, is it something that's coming to me, or is it for the court?
Ms. Kraus, can you address that? It should be going to you.
Yeah, it would take 3 to 5 business days for there to be
Okay.
something coming down, but it's not going to happen today.
Okay, sounds good. Thank you so much.
Okay, thank you. All sides are free to disconnect on this case.
Thank you, Your Honor.
Thank you, Your Honor.
Give me a status of this file today.
Yes, this hearing was adjourned from January 6th for the defendant to provide the friend of the court with his gross monthly income in writing to the friend of the court for a support recommendation and make his monthly support payment. Since the hearing, the defendant did drop off a letter but did not indicate his current gross income. And there's been no additional payments received since the last hearing. His obligation is $513. The balance on the account is $21,023.21. The specific payment that was pending at the last hearing did disperse to the case in the amount of $1,000.
All right, thank you. Mr. Dushane, what's your status here?
So, Your Honor, I since just about 10 days ago, I received a letter from the friend of the court saying that my hearing was the hearing she was just talking about was terminated. So I didn't turn any information in because I have paperwork from the supervisor at the friend of the court saying that my hearing was terminated because of lack of information. In regards to, and I wish I had that paper here, but she has to have seen it. In the regards to the payment, you told me to make a payment of $513 in 30 days. I should be able to make the payment. I'm finishing a job up tomorrow and I should be able to make that payment this week. I don't have it today. I did make $1,200 or $1,400 worth of payments to all of my child support in the month of January. And I do intend to make those payments this week. I won't have the money until I finish this job, which should be tomorrow. And that's all I have to say, I guess.
All right, Ms. Kraus, do you have any information about this letter that he's talking about?
I'm looking right now, Your Honor.
I have it too. I can find it really quickly, Your Honor.
So it does look like an auto-generated. It does appear that an auto-generated letter went out in regards to the termination due to the lack of information, and it would be eligible for review again after March 4th of 2027, unless there's a reasonable change in circumstances. And it still outlines that he has the option to file a motion.
All right, so that's just dealing with the review of the amount.
Correct.
Okay, all right. All right, so Mr. Dushane, if I give you a 7-day period here, if you're finishing up that job tomorrow to make that payment, can you do that?
Absolutely, 100%, Your Honor. I know for sure, yes.
Okay. All right. So for purposes of today's hearing, the court's going to order that you make that payment within the next 7 days. You know, the last hearing, we probably are short of exactly 30 days, and I do believe that's what the court stated on the record the last time. Ms. Kraus, if you can set this again. Well, Ms. Kraus, what I'd like to do, I guess, is monitor that payment, because I'd like to, if that payment isn't made, then I'd like to get this set for hearing. You know, not necessarily on a normal motion day, but as quickly as we can after that 7-day period, if the payment isn't made.
Okay.
Because I want to make sure that that it is made within that period of time. So, Ms. Kraus, if you can, in the order for today's hearing, I'd like it to indicate that Mr. Dushane needs to make that payment within the next 7 days, or be subject to further contempt proceedings. And then, Ms. Kraus, if you can, you know, just put a marker on that, or in some way notify the court if that payment isn't made in 7 days, so that I can ask Jennifer to schedule a hearing sooner than March.
Okay, and then for clarification, what was the amount? Just his support obligation, nothing towards the arrears?
Right. Whatever I ordered last time, I think Mr. Dushane was like 513. Yep. Yeah.
Thank you.
Okay. All right.
So, Your Honor,
yeah, go ahead.
So I was confused that I got that termination paper because I thought that I was under order to turn that information into you within 30 days or have it. So I wasn't really sure what happened. Maybe I should have went through with it anyway, but I just thought I lost my chance for whatever. Is this termination? Do I have to file another motion? Was that closed wrongfully, or how do I go further with that? Or do I not?
Ms. Kraus?
So the review was requested by yourself, indicated in that termination review. In order to move forward with that, you have the option to file a motion versus indicating the request review, because you initiated it and the information wasn't requested or wasn't received.
Okay, thank you.
All right, Ms. Nolasco, did you have any questions at all?
So right now, pretty much is that we're doing another review and we're giving him a week, 7 days, business days to get that $513 for that. And then what happened if anything, like if he does half of it again, like what he did before?
Then the court's going to schedule a contempt hearing, and we'll go forward with contempt.
Okay, and I will receive information about that
Yes.
in the mail? Okay.
Yes. No. Okay, all right, thank you. All parties on this case are free to disconnect at this time.
8-9.
Thank you.
Thank you,
We have
Honor.
either party on that matter present.
Yes, Your Honor. Andrew Dibble.
Thank you. And in front of the court, what is the status of this matter?
The defendant has a support obligation of $1,016. This sum is composed of $916 for current support and $100 as an ordered on arrears, with a balance of $11,402.50. The defendant did call yesterday and made a $4,500 payment that is still pending, and obtained a hearing date for a motion for support for January 22nd. Outside of this pending payment, there has only been 2 payments for this case. $2,950 in August, and a show cause was removed due to that payment, and a purge payment of $6,000 was received in April to not appear in front of Judge Hunter.
Thank you. Mr. Dibble, what would you like to say?
Yes, sir. I made that payment of $4,500 to start making to make back on past due, as well as create the ability for talking to Shasta with Friends of the Court. I am finishing my MBA. That's why I haven't had employment. I'm finishing my MBA in marketing and education, and I'll be able to pursue teaching positions starting February 1st. But I have been working part-time, and I did get a income withholding form submitted through, it was given to my employer. It's just a part-time thing, but also I will begin substituting again, which I will give that documentation as well. And my only income right now is through VA disability. I have received I requested the form from the VA to have the child support withheld from there. I thought the VA had sent me a form. I thought that was an income withholding form, but it was not. It was just them stating something. So I misunderstood that, but I have filled out that form and submitted it to the VA for the child support and the arrear amounts to come out, I believe, starting December 1st.
Okay, and is it accurate that you're filing a motion also for January 22nd?
I am, yes, sir. That motion is filed just because the amount that was determined was based off of prior income when I lived outside of Michigan. The motion is to go back and look at it with just my VA disability, as that's all the income that I'm receiving right now.
And do you anticipate being able to make some additional payments prior to that January 22nd date?
Yes, sir. I plan on making a payment December 1st, as well as January 1st.
Okay. What we're going to do then is adjourn this matter to January 22nd to monitor those payments and then see where we're at also with your motion.
Thank you, Your
So
Honor.
I'll expect to see those payments, sir. Anything else that you need to say?
No, sir.
All right. Thank you for appearing today. You are all set. Anyone present on that file? Either party is present. It is 10:23. The matter was set for 10:15. In front of the court, what is the status of this matter?
This hearing was adjourned from November 20th to monitor payments and be heard along with the defendant's motion for support. The support motion was not filed with the clerk. The defendant reported a new employer on January 17th, and that he indicated he would be in a training at the time of this hearing. Confirmation from his commissary offer letter from the employer did indicate that information. He did submit a $4,500 payment in November. The defendant's obligation is $1,016. The sum is composed of $916 for current support and $100 towards an order on arrears, with a balance of $8,755.50.
Thank you. Well, given this communication, the caseworker indicating that he would have training today, and with that verification, I do believe it's appropriate to adjourn this matter. We'll adjourn out a couple of months just to see where that employment's at. So let's adjourn to March 12th. Present on that matter.
Thank you, Dibble, sir.
Good morning. For the court, what is the status of this matter?
This hearing was adjourned from January 15th when the defendant failed to appear, but had prior contact with a friend of the court. He would be in training at that time. Since the hearing, a payment of $318.94 was made by an income withholding. The defendant's support obligation is $1,016. This sum is composed of $916 for current support and $100 for overdue support.
Thank you. Mr. Dibble, anything you'd like to say regarding this matter?
Yes, sir. I spoke to friends of the court. The income withholding will actually increase. I was just going through training with my new employment with the ABA center, so that'll increase my hours for training. Were a lower amount. I'm now working anywhere between 35 to 45 hours a week at the billable rate for insurance instead of the training rate. So that will increase and be able to fulfill that obligation.
All right, what I'll do then is adjourn to June 11th, just to make sure that's happening. If everything is running smoothly, then the front of the court may remove that off the docket. You might not have to appear, but we'll have that date there in case there's any issues, okay?
Yes, sir. Thank you.
She has popped on. Thank you. You're all set. 27 minutes late for his hearing. So we'll go to Mr. Dory and listen to his excuse.
Sir, I was already in. It threw me off. I was already on the line, on the phone, and I heard when you called, and I heard everything. I was already there. I heard the last with the female, and she wanted to give the arrears and said he wasn't making. I heard everything. I was here. For some reason, you guys couldn't hear me, and it threw me off.
Okay. All right. Did you hear, the status of your case?
No, that's when it came to my name, it hung up.
All right. All right. So, front of the court, could you run through one more time the status of Mr. Dorchy's case?
Yes, the hearing had been adjourned twice, most recently from October 2nd to monitor self-payments from the defendant until the income withholding from its employer becomes active. There's been no payments since the last hearing. The defendant did contact a friend of the court to report a new address, but has not submitted the change in writing for the friend of the court to update its records. His support obligation has decreased due to the emancipation of a child. His new support amount is $334 as of the 1st of November. The current balance on the account is $2,918.92.
Thank you. All right, Mr. Dorchy, what would you like to say?
Okay, I'm back home. I came back to Michigan. I'm home. I can do that right now. I had to move, but I came back here because I have a sick son. I have full physical custody, and the $16 an hour wasn't enough. So I came back here to make more money. I have a job interview here at 10:30 at American Steel, which sounds promising. And I have another one tomorrow also. But I'm back here. I will update my address. I'll come see. I called to talk to Shasta, but she wasn't in. And realistically, I have to be here to get a little more help with my son. Between that and trying to get him at my schedule that I was working, it wasn't enough helping. So I decided to come back home to Michigan. And I have everything set up. I will come in face to face and give you guys an updated address here face to face. Other than that, I'm just in between homes. I'm staying with a friend right now. I'm getting a place ASAP. I can make payments on my first paycheck. I could probably catch everything up. What's this, December? By the end of December, I can catch my arrears up and start back making payments. But now that my daughter's 18, I don't even know how much I should be paying a month now. So I have to do a real evaluation of that too. But I just came back home. I came back to Michigan. Just got here.
Are you willing to provide your address now verbally, or do you want to come in and do that?
I'll give you my address right now.
Okay. What is that address, sir?
This is 074, right near Port Huron.
All right, for the court, you need him to run through that again, or do you think you have it?
21.
And it's apartment 1?
Yes.
Okay. All right, so I will order the front of the court to
Yes, sir.
update
Yes,
that.
sir.
All right, so they'll update that address. What I'm gonna do is adjourn your case out a little bit, sir. I'll set you for January 15th, so that will give you December, obviously. As you indicated, you think you can make a significant payment on this matter. So we'll come back January 15th
I
to
will.
see where you're at. Obviously, if you do get a new job, make sure you let friend of the court know. And then, like you said, once you start receiving paychecks, make sure you're making payments until there's an income withholding order in place. You need to make those yourself directly, okay?
Yes, sir. I got you. Yes, sir.
All right, thank you for being here, sir. We'll see you back here on January 15th, okay? Anyone is present on this matter, they need to unmute and identify themselves for the record. Having heard no response, front of the court, what is the status of this matter?
This hearing has been adjourned 3 times, most recently from November 20th to monitor the defendant's employment status and payments made by the defendant until the income withholding is active. Since the hearing, the defendant has updated his phone number only with the office. The friend of the court has received another potential employer from National New Hire, but no payments have been received or contact from the defendant regarding where he is employed. The support obligation is $334 and the balance is $3,607.92. The last payment of $733.08 was received in July of 2024 from a prior income withholding.
Thank you. And Mr. Dorsey resides out of state, is that, or is he in state?
I believe he's back. At the last hearing, he indicated he was
Okay.
back in the state.
Excuse me, Your Honor.
Yes,
Mr. Dorsey was just appeared in the waiting room. I just brought him in.
thank you. Mr. Dorsey, I have called your case. If you could please unmute.
Yes. I'm here. 1 second. Let me turn the phone off. Okay. I heard everything. They should be taking payment out, and I'm also I have an interview here at 1:30 for a second job. I'm trying to catch everything up, but when my taxes come, I want to catch everything up. But I'm getting a second job. I have to put my son through daycare so that way I can get more hours in. So, and they said that's fine. So I just want to go ahead and just put that on the record that I'm actually getting a second job.
Who are you working for now?
It's called MC. They're called MNC Assembly. MNC Assembly.
And out of what city?
It's a contract job in Harbor. What is this? It's in the harbor. Port Huron. I'm sorry, Port Huron. Where I'm at, Port Huron. But they wanted to send me to Traverse City, but it's a job that we do assembly work around the state, and it's a traveling job. But I could get more hours once I get my son in daycare. But I'm picking up a second job, so that way I could pay for daycare also.
Have you received any paychecks yet?
I received one paycheck, and I believe they took it out. I'm not sure if they did or not, but I did gave them information, and I did receive a paper here in the mail saying that you guys are receiving payment.
Front of the court, is that accurate or not accurate?
I believe the information he's indicating is he would have received a copy of the income withholding that was sent to the employer. But as of yesterday, there's been no payment. I don't know when he was last paid. Sometimes if there is a minimum amount of time to allow a payment.
So, sir, sometimes it takes a little bit of time for everything to get registered and cleared. So the indication is there hasn't been anything taken out yet.
Sure.
So you need to pay attention to your checks. If nothing's coming out, you need to make a payment yourself. Do you understand that?
Sure. Yes, sir. I do. Yeah, sure.
If you get another job, you need to make sure you let your caseworker know that also. I'm going to adjourn you to March. Well, I'm going to adjourn you to February 19th, actually.
Okay.
Just to get the update and to make sure that you're either making a direct payment yourself or that the income withholding order is in place, okay?
Okay.
Your Honor.
Sounds good.
Yes.
Would it be possible for him to contact the office? Because I know prior when the contract jobs that he's had, it's been a hard time for us to make sure which company that he can address where the HR is and a contact number for that.
All right. So, sir, can you contact the front of the court later today?
Sure. I'll call and talk to my social worker.
Call your caseworker, yep.
Okay.
But she'll be in court most of this morning until Well, if you call after 11 this morning or this afternoon, that would be helpful, okay?
All right, sounds great. I got it.
All right, thank you. You're all set. We can sign off. DM, do you have anyone present on that?
Good morning, Your Honor.
Good morning. We have Mr. Briggs present. In front of the court, what is the status of this matter?
This hearing has been adjourned 4 times, most recently from January 15th. The defendant was expected to make full monthly payments until an income withholding is active. Since the last hearing, the defendant contacted the friend of the court on February 14th and left a voicemail to report employment, but would call back with more information. There has been no payment. His support obligation is $334 and a balance of $3,941.92.
Thank you. Mr. Dory, anything you'd like to say?
Yes, I start work tomorrow. I did talk to my contact Shasta, and I let her know I was just waiting for my background to clear, and they told me I could start tomorrow. And I will get a hold of her so she can get all the information I need. And my first paycheck comes straight to you guys.
When you were here last time in January, I thought you said you had employment at that time and you were looking for a second job.
I did, and it slowed down so much they didn't even call me back. So I was looking for another job, and they recently called me back for this second job. So yeah, and the other job that I had was contractor work that didn't pan out. It slowed down a lot. Was no work. So I've been picking that up.
Last payment was in July of 2024. It was a prior income withholding of $733.08.
Thank you. All right, sir. Anything else you want to say?
No, sir. Just that's it. I work tomorrow, and I'll get a hold of Shasta, and as soon as I get my paycheck, it goes straight to you guys. And also, when my taxes come, I was going to pay everything up with my arrears.
All right. Thank you. All right. So given the status of this matter, we've repeatedly adjourned it, repeatedly been told payments would be coming, and every time payments don't come. So I am going to make a recommendation this matter be set before Judge Hesseling for a contempt hearing. There obviously is an arrears in this matter. I'm satisfied that you have the ability and the capacity to pay some portion of the amount to due, and no payment has been made since July. That you have not exercised diligence in getting it paid into the court. So I will set you before Judge Hesseling on April 11th. I would indicate that if you make a payment of $2,000 prior to that court date, then you would not have to appear on that court date. Obviously, you're still obligated, sir, to make sure you are letting your caseworker know about any employment, working on getting an income withholding order established, and making any payments until that order is in place. Do you have any questions, sir?
Sorry, I lost you there.
All right. Do you have any questions, sir?
Yeah, I lost you there. You said that I will meet with I have the $2,000 payment before my next court date.
If you pay, so I'm setting you for a hearing before the judge, a contempt hearing before Judge Hesseling on April 11th. If you pay $2,000 prior to that court date would be canceled. If you don't pay that amount, you do need to appear for that court date before him.
Gotcha. Okay.
All right. You're all set for today. Thank you.
Thank you.
717 DS. We have either party on that matter present.
Yes, Your Honor.
All right. You are Mr. Van Horn?
Yes, sir.
Okay. I know Mr. Van Horn has a few cases, so I will do them all, call them all at once. You also have the matter of Nicole Garcia versus Sean Van Horn, 2009, and Megan Van Horn versus Sean Van Horn. Do you have any of the mothers present on those cases? Okay, it does not appear that either of in those cases, the mothers are present. In front of the court, what is the status of Mr. Van Horn's matters?
Okay, his case with Ms. Payton is an arrears only case. He has an order on arrears of $73, and the current balance on the case is $3,246.18. Last payment received for this case was in March of 24 in the amount of $126.65. His case with Ms. Garcia, he has a monthly support obligation of $294 with an ordered on arrears of $50. Current balance is $3,704.16. Last payment received was in August of 24 in the amount of $266.43. And lastly, his case with Megan Van Horn, it has a monthly support obligation of $295 with a $50 ordered on arrears. Balance is $3,060.01. Last payment received was in August of 24 in the amount of $267.34. I did speak with Mr. Van Horn 2 days ago regarding a new job. He said that it's going to take a little bit to get the paperwork portion of that all sorted out. However, it does sound promising, and for that reason, I would like to adjourn the matter to see if we can set up an income withholding order and get the automatic payments.
Thank you. Mr. Van Horn, what would you like to say?
Well, Your Honor, that's exactly what happened. I've just been struggling a little bit. In March, I was doing well, but I was in a car accident last winter, and I ended up taking some cannabis gummies, and I shouldn't have, because I am a CDLA carrier, and through the federal government, I am not supposed to be using marijuana, but I took some gummies for my pain, and I was given at random through my my employer, and my CDL was taken from me for a bit. They put me on a SAP program, a substance abuse program. It took me about 6 months to complete the program. I currently completed the program. I have my CDL Class A back. So it's been a minute for me to find a job. But I did find one 2 days ago through GFL Environmental here out of Harrison. And I'm currently in the process of the hiring process. I'm having to work with the federal motor carriers right now, just making sure everything lines up. And it's just going to take probably another week or so for them to look at the clearinghouse, make sure everything's lining up. And that's kind of where I'm at right now. So the last 6 months have been kind of hard for me. I did make a mistake. I knew better, but and that's kind of where I'm at now. But I did correct the matter, and that's where I'm at.
All right, I will follow your caseworker's recommendation and adjourn your matter. I think there is good cause to see where we're at with this employment. I'll adjourn you to January 15th. Obviously, make sure you keep her updated regarding that job. And then if you start working and there's not an income withholding order in place right away, you need to make sure that you're making payments directly until that order is in place. Any questions, sir?
No, sir. Thank you.
All right. Thank you for being here. I'll see you January 15th.
Thank you.
Does not appear that anyone is present. From the court, what is the status of this matter?
This matter was adjourned from November 20th to monitor the defendant's employment status and new income withholding order. You also told him that he needed to pay until the income withholding order was active. This particular case, it is in arrears only with $73 ordered on arrears and a current balance of $2,857.75. Last payment received was in March of 24 in the amount of $126.65. I did speak with him on the 6th, and he confirmed that yes, he was in fact hired by GFL. Income withholding is pending. I also reiterated with him the importance to make some sort of payment on his own until the income withholding order was active, and we discussed the importance of being here today. When I talked to him on the 6th, he had every intention of being here.
So the income withholder is not paying yet, but it's
correct. It's not. It's pending still.
Well, if he is actually working that job, I would rather not do a benchmark at this time. We can get some payments because I know he does have several files. So I'll just give this a brief adjournment to see if we are collecting on that or not. As well as give him another opportunity to appear. We can adjourn to February 12th. Calls other matters. So first, Nicole Garcia versus Sean Van Horn, file 09-1. Anyone present on this matter? Given the same information regarding his potential employment, pending income withholding order, I will adjourn this matter to February 12th. For next call matter of Megan Van Horn versus Sean Van Horn, file number 17-. Anyone present on this matter? Once again, given information regarding a pending income withholding order for Mr. Van Horn, I will adjourn this matter to February 12th to see if that starts to collect. It's not appear that either party is present. In front of the court, what is the status of this matter?
This matter was adjourned from January 15th. The defendant has an arrears only case with an ordered on arrears of $73. Total balance is $2,857.75. There is an active income withholding, however, it has not pulled enough to be applied to this arrears only case. It did apply to his other two cases that you're hearing today. The last payment we have received for this specific docket was back in March of 24 in the amount of $126.65.
Given that there is an active withholding order, I'm going to adjourn this as well as his other matters. Just a short adjournment to March 19th to make sure that that is still collecting and see where we're at. Also, the next call the matter of Nicole Garcia versus Sean Van Horn, 09. Anyone present on that? Not a few either parties are present. So this matter is getting some money through income withholding order. Is that correct?
That is correct. We have received $193.58. And his support obligation is $294 with $50 ordered on arrears. And the current balance on his account as of today is $4,413.58.
All right, I will adjourn this matter to March 19th again to monitor that collection on that withholding order.
Yes.
All right, Mr. McCluskey is present. In front of the court, what is the status of this matter?
This matter was adjourned from October 2nd to monitor payments made and to see if the defendant filed any motions. No motions have been filed as of today. He does have a support obligation of $534 and a current balance on the account of $4,232.67. The last payment received was in October of 24 in the amount of $450.
Thank you. Mr. McCluskey, what would you like to say?
I made more payments than that. I got receipts here I can put on the screen. I just made another one in Oakland and I made another one online. On November 15th, I made one of 200 at Oakland County in front of the court. I can show you the receipt if you'd like.
That was for this matter or for another case?
For this case, here it is.
That was $200, you said?
Yes, sir. And I'm still in the process of filing the motion. Tasha and I had an agreement and she fell through on the agreement we had, as I told the court last time. And now she cut all contact, and Kylie's not even in school, actually. And we had an agreement to lower the support once I helped her out and done everything I stuck up to my end of the obligation. And I'm still in the process of filing the motion. My back went out, and I was sick for almost 3 weeks. So I'm going to get back on it this coming week to file it and send it all in.
All right. Well, I think we talked about it before, obviously, until there's a order changing the support, that amount is, the expected payment. We'll certainly review the motion once that is filed. I'm going to adjourn your case to January 22nd.
Okay.
And that is to make sure that you meet your obligations for November and December.
January 22nd?
Yes, sir.
Okay, yeah, then I'll get that motion filed because I can't afford the monthly obligation that's set. I mean, there's no way I can afford to pay that amount.
All right, well, it's pretty quick and easy to file that motion. So you just need to take care of those steps, okay?
Okay, then it's 9:30 a.m.'s the hearing time?
Yes, sir.
All right, thank you.
Thank you.
Yes, sir.
All right, we can hear you, so that is important. In front of the court, what is the status of this matter?
This matter was adjourned from November 20th to monitor payments for both November and December. The defendant's monthly obligation is $534 and the current balance on the account is $4,871.67. We received payment in December in the amount of $250. November was $200 and October was $450. You should also note that the defendant has filed a motion regarding support, and that hearing is to be set in March of 25.
Thank you. Mr. McCluskey, what would you like to say?
I did file the motion. I've been paying what I can pay to. I've been paying every month what I could afford to pay. I'm not just trying to skip it or nothing.
All right, what I'm going to do on the show cause is I'm going to adjourn it to that same date as your support motion. Looks like that is March 19th at 10:15. So we'll hear both issues that day. Obviously, sir, you need to continue to make a monthly payment, okay?
Okay, thank you.
All right, we'll see you then.
Yes.
Good morning. We do have Mr. McCluskey present. This matter is set for a show cause hearing, as well as then appears a motion regarding support. Mr. McCluskey, it's your motion regarding support, is that correct?
Yes.
All right, what would you like to say regarding that, sir?
Tasha and I came to an agreement to lower my support, what I could afford, about $250 to $300 a month. We came to agreement to get a loan. I did, to provide Kylie with all of her school clothes, 3 pairs of shoes, and to pay her cell phone bill for several months. And Tasha would lower the support to $250 a month. I contacted the court worker multiple times, and Tasha kept failing to meet me there or to go there after I'd done everything she asked. And my support said I can't afford that amount right now.
All right. Did you and her have any written agreement?
I got it in text messaging from her multiple times.
Okay.
We were supposed to meet at the court to sign together, the worker told us, when I was up north working, and Tasha failed to meet me.
Okay. And in front of the court, any information on this matter?
He has expressed that to us, however, we would need her to sign off on that money that is either direct payment or arrears forgiveness. If they're willing to do a stip, then, you know, again, that's gonna require both of their cooperation.
Okay. And then as to the show cause.
So he was here before us last time on January 22nd, and we had adjourned the matter to allow the defendant a chance to file this motion, and that he was to continue to pay each month. His monthly support obligation is $534, and the current balance is $5,389.67. We received a $300 payment for this month, no payment in February, and in January we received $250.
All right, Mr. McCluskey, anything else that you wish to say?
Yeah, I paid every month.
All right. Are you meeting? How much are you paying every month?
$250 to sometimes $300. I paid in person in Oakland County multiple times and on the website.
Okay.
I have all.
And what is your monthly support amount?
5 something.
Okay.
$534.
February I paid also.
Do you plan to pay the $534 a month, or are you sticking at this agreement that you think you have with Ms. Butts?
No, I just can't afford the $534, sir. If I could afford it, I would be paying it.
All right, so we're here today on the motion regarding support as well as the show cause. I am going to deny the motion regarding support. I don't have Ms. Butts here to confirm any type of agreement to lower the amount. So the court is not in a position to do that without Ms. Butts agreeing to lowering it based on what the parties have. So that motion is denied. As to the show cause, we've not been meeting the amount, but some type of payments are coming in, but it doesn't appear that Mr. McCluskey feels he can meet the amount that is ordered. So adjourning it doesn't make sense necessarily to me, because it doesn't sound like you don't intend to pay more than the $250 or $300, which would still not satisfy the amount that's ordered. So given that, I am going to recommend a finding of contempt and the matter be set before Judge Hesselink. I do find that there is an arrears and that there is the ability to pay under this order, and the full amount is not being met. That with the exercise of diligence, there is a capacity to pay all or some portion due. I'm going to set it out to the May 9th docket for Judge Hesselink. I would indicate that if a payment of has there been a March payment then, you said, I think correctly?
A $300 March payment.
Okay. So if $800 is received prior to that May 9th hearing, then that matter would be canceled, and then we would just proceed forward with any other potential show causes if payments aren't met. Any questions, Mr. McCluskey?
Yeah. Also, Kylie's not even in school. I mean, what do I do about that? File a motion on that also?
If you have parenting time or custody issues or other support issues, yes, you would need to file a motion.
Okay. Yeah. All right.
All right, thank you, sir.
You're
We're all
welcome.
set. DP, do you have the parties on that matter present?
Yes, Your Honor, I'm right here.
All right, good morning. We do have Mr. Samson present. In front of the court, what is the status of this matter?
This actually is a part. There is a show cause, and he's also requesting to have his license reinstated. He's before us today because there was a bench warrant that had been issued back in March of 2022. We did enter into a stip with him, and he's been making consistent payments and has done everything that we have asked him to do. His support obligation is $102. He has a current balance on his account of $4,159.65. For November, we have already received $119.47. We can dismiss the show cause.
Thank you. Mr. Samson, what would you like to say?
What was that you say, Your Honor?
Anything that you would like to say?
Hold on, I can't hear you loud where I'm at.
All right. Is there anything that you want to say on this matter, sir?
Oh yeah. Well, I'm working. I have my son on my insurance. I get Blue Cross Blue Shield, and I get my check get garnished every week for child support. So I pay every week, and I'm also like doing partial payments myself. I got proof that I send my son money through Cash App as well. So I was like, I'm hoping that it was possible for me to get my license so I can like go up north to see him instead of catching the bus or catching rides. This is kind of hard without having a license to do anything.
Okay. Well, given the information from your caseworker that you have now kind of gotten into compliance and there is regular payments, given that information, I will grant your motion to rescind the license suspension.
Thank you, Your Honor.
And then just make sure that you continue to make those payments so we're not back at having to do that again. Okay, sir?
Yes, Your Honor. I will keep making my payments, I swear.
All right. Thank you. You're all set. Thank you, Ms. Sylvester. And in front of the court, what is the status of this matter?
Maybe the gentleman in the bottom right there is trying to talk.
Do we have Mr. Whitridge present?
That is
I'm here, sir.
yes.
All right. Now we got him through. Okay. And in front of the court, what is the status of this matter?
This matter was adjourned from October 2nd to monitor his October payment. He has a support obligation of $211 and a current balance of $8,727.71. Last payment received was in September of 24 in the amount of $200. And I do believe we may need to verify that we have the correct phone number on record if he's comfortable sharing that.
Thank you. Mr. Whitridge, what would you like to say regarding this matter?
It's been a rough summer, sir. I've been trying to make payments. I've been pushed out of a couple jobs. I did have a job where my boss was picking me up for work, and I lost that job again. And I started working in 2 days at the Amazon warehouse.
All right. You are in Gaylord, is that correct?
Yes, sir, it is. You guys should have the correct address for me.
All right. I think we do. And then do you mind providing a phone number or do you want to call the caseworker and provide that?
My phone got shut off due to lack of working, sir. I've been using Wi-Fi to get a hold of people and stuff like that.
All right. Just make sure you update that when it is back in service.
Yes, sir.
Where are you at with making a payment, sir?
Like I said, I've been trying to do cash jobs for money, and that's how I was able to make those couple payments through the summer. And I won't be receiving a paycheck until whenever Amazon, after I start on the 22nd here.
You start on the 22nd?
Yep, in 2 days.
Okay. Ms. Sylvester, any questions or any comments that you would like to have?
No, sir.
Okay.
I'm used to excuses.
I understand, man. All right. So Mr. Whitridge indicates he does have a job starting in a couple of days, so I will adjourn the matter to allow that job to start, as well as to get an income withholding order in place. I will adjourn it to January 15th. Mr. Whitridge, obviously, if you get a paycheck before there's a income withholding order in place, which is likely, given the paperwork, you do need to make a payment yourself, okay?
Yes, sir.
So when we come back in January, I would expect that you at least met the obligations for November and December. And then we'll talk about a plan on how we're also going to meet the monthly obligation and work on getting this $8,000 balance down, okay?
All right, sounds good.
All right, thank you both for appearing. You both may sign off.
Thank you.
Thank you, sir.
3EM, do you have anyone present on that?
I'm here, sir.
Thank you. We do have another phone number that just joined. I'll make sure that that's not anyone involved. Court has called the matter of Pamela Sylvester versus Clark Whitridge. If Mr. Whitridge is present, you need to unmute and identify yourself. Not appear that we have Mr. Whitridge present. Front of the court, what is the status of this matter?
This matter was adjourned from November 20th to establish an income withholding order for the defendant. And you had also instructed him that he must pay himself until that became active. His support obligation is $211 with the current balance of $9,097.03. The income withholding order appears to have just become active this month, and we have received $73.68.
Thank you. Ms. Sylvester, what would you like to say, or any questions that you have?
No, sir. That's true. I got a $73 payment last Monday.
Okay. What I'm going to do is adjourn this matter out since he's not here. I just want to continue to monitor and make sure payments are coming in. I'm going to set it out a little bit further just to make sure those payments are happening. So I'll adjourn his matter to March 19th.
Thank you, sir.
Thank you. Thank you. You're all set. Looks like Ms. M. Do you have anyone present on that matter? Does not appear that either party is present. For the court, what is the status of this file?
This matter was adjourned from January 15th to monitor the defendant's income withholding order. He does have a monthly support obligation of $211 and a current balance of $9,223.19. The income withholding order does seem to have recently taken effect. We received $147.92 this month and the same amount for last month. Considering that we're now getting payments in, I think we should adjourn out and then potentially address order on arrears at the next hearing.
Thank you. Given the active income withholding order, I will adjourn the matter to June 11th. Sidel has been patiently waiting. Is that you, Mr. Sidel?
Yes, Your Honor.
All right, thank you. In front of the court, what is the status of this matter?
Your Honor, the defendant was failure to appear at his show cause hearing on September 18th. Consequently, a bench warrant was issued. On September 20th, we entered into a stip that was signed by the judge where he agreed to pay $1,000, which he did do, and that he was also going to maintain an income withholding or pay $400 monthly plus something towards the arrears, which he has not done, and that he was to appear today. He has a monthly support obligation of $400 and a current balance of $12,248.50. The only payment we've received is the one from the STIP.
Thank you.
This is a court order.
Mr. Sidel, what would you like to say?
Your Honor, I just recently graduated from recovery court in Otsego County on October 22nd. I had 60 days of community service that I had to fulfill to be able to graduate. So that kind of limited my work ability. I also have filed a motion down in Charlotte County, Florida. Both of the children have been here with me in my custody for a year now. One of them's 2 years. The other one has been here since December of last year. So it's been pretty difficult for me getting this motion filed. I had some issues with an attorney down there. And so I just filed the motion the beginning of October. I haven't heard anything back yet. I'm trying to get the custody modified so my arrears doesn't keep accumulating. And I don't believe that the number is accurate. This has been a really confusing thing for me for the last several months. I was receiving things from the state of Michigan saying I owed one thing, and then stuff from Charlotte County, Florida saying I owed something different. I've made multiple trips into the front of the court in Gaylord, trying to resolve this matter. But right now where I'm at is I'm just waiting to hear back on this motion that I filed. I'm trying to get the arrears amount modified because I don't believe it's accurate.
Well, the difficulty is you signed a stipulated order that was entered by Judge Hunter in September that said he would pay $400 monthly, and it sounds like that has not been happening. Is that correct?
So I did provide them with my new employer's address, and I know that they filled out an income withholding, so I'm not sure what's going on there. But at least a month ago, an income withholding had been, all of that got processed.
All right, front of the court, do you know anything about a income withholding order?
We did establish one, but no payments have been made from that.
All right. Are you still working for that company, sir?
Correct.
And did you work there throughout September and October?
Yes.
And did you notice anything coming out of your check for payments?
No, I did not.
Well, if nothing's coming out of your check, then you got to obviously make the payment yourself until that happens. It doesn't appear that was done. Are you able to get a payment into the court here promptly?
Yes, I can.
What I'm seeing then is you didn't make your October payment, and now we're almost at the end of November. Are you able to get yourself back on track with at least that $400 payment?
I absolutely can do that. Yes.
That'll be two $400 payments by the end of October or end of November. Are you able to pay $800 before this month is over?
I'll figure it out. I can make it happen.
Any way of squeezing them into December?
Yeah, we can make it.
All right.
Your Honor, can you give me just a second? I'm sitting in my truck and my breathalyzer just went off. Is that okay?
All right. Yes, sir.
Sorry about that.
We can have the hearing, we could do December 18th at 9 a.m.
Okay. All right. So, sir, I'm going to adjourn you to December 18th at 9. However, if you have paid $800 prior to that date, and that would represent your October and November payments, you do not need to be here on the 18th, okay?
Okay. Can I just verify? I'm pretty sure I provided friend of the court with my new address. Can I just verify that they have my current address?
Absolutely. What is that address, sir?
4680.
All right. Thank you, sir. So again, if you make an $800 payment, you don't need to be here on the 18th, but if you haven't made at least $800 payment, you do need to be here, okay?
All right. Thank you.
The parties on that matter. Thank you. You're all set.
Yes.
Yeah. All right. Thank you. We do have both parties present. This is an initial hearing to address custody, parenting time, and support. Ms. Lyons, you are the plaintiff, so I'll ask you first. Do the two of you have any agreements when it comes to custody and parenting time and support?
Yes.
All right. And what is that agreement?
So we have agreed to 50-50 custody. We've agreed to a certain amount in place for like a child support amount for each month. We've agreed to shared holidays, and we have agreed to a school system or school district.
Okay. Is there any public assistance that you or the children receive?
No.
So your request is for joint legal, joint physical custody. Do you have a specific parenting time schedule, or is that just going to be as the two of you agree?
We do 4 days on, 4 days off.
Okay. And you have your own holiday schedule, is that correct?
Yes, I would say so. We're just going to split holidays, half days.
Okay. So the support amount's going to be a little bit of a trickier issue. What we're going to do is the front of the court has to run a support recommendation. Okay. I'll have them run that recommendation, and then once that is ran, if the two of you have a different amount that you wish to pursue, you file an objection regarding that recommendation and come back before me. But that way, both parties can see what the formula indicates the support amount should be. And then if there's an appropriate reason to change that or deviate from that amount, we would discuss that at that time.
Okay.
Mr. Allward, do you agree that that is the agreement the two of you have?
Yeah, we talked again this morning, and that's what we have agreed on.
All right. All right. So, Ms. Lyons, I'll go back to you. Would you please raise your right hand? Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
Ma'am, is it correct that you are asking the court to enter an order that gives the two of you joint legal and joint physical custody of the minor children?
Yes.
And you're going to have a parenting time schedule of 4 days on and 4 days off. Is that correct?
Yes.
You're also going to share holidays as the two of you agree.
Yes.
And you feel this agreement is in the best interest of the children.
Yes.
Thank you. Mr. Allward, would you please raise your right hand? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
And sir, are you also asking the court to enter a order that grants the two of you joint legal and joint physical custody?
Yes.
And you would have a parenting time schedule of 4 days on, 4 days off. Is that correct? All right, Mr. Allward, we lost you there for a second.
Yeah, I'm sorry. Phone call came in. I denied it, and so I'm back.
No problem. So you have agreed to a 4 day on, 4 day off parenting time schedule. Is that correct?
Yeah, that's my work schedule. So she agreed to it. So thankful for that.
And you're going to share holidays also as the two of you agree. Is that right?
Yeah, we'll just spend them together, do half days or whatever we have to do to see the kids on each holiday.
Okay. And do you believe this agreement is in the best interest of your children?
Absolutely.
All right. So I will also have front of the court prepare a support recommendation. As I mentioned to the two of you, once you get that, you do have the right to object to that. So if you want to proceed and request a different amount, you would just file an objection, come back before me, and we would address that. Front of the court, do you have all the information you need to prepare a support recommendation?
No, we would need the information that was requested in the welcome packet.
From both parties?
Yes.
All right. Did you guys get?
I'm sorry, I don't mean to interrupt. I was going to actually ask about that because we do both still have our packets. We both realized this morning that we had not filled them out and sent them back in. We both did not complete the SMILE class either. Are those all things that we still have to do?
You have to do that, yes. So okay. I'm going to recommend that you complete those paperwork and get those in within 14 days as far as the questionnaires so that a support recommendation can be prepared. And you will need to complete the SMILE class before your case can be finalized.
Okay.
All right. Thank you both for appearing today. That does conclude the matter.
Okay.
All right. Thank you.
3DS, other parties on that matter present.
Yes.
All right. Thank you. And Ms. Hodge, can you hear me okay?
Yeah, I can hear you okay.
All right. So my understanding is we're here today on Mr. Salah's motion regarding parenting time. Is that correct?
Yes. That's correct.
All right, ma'am. Could you please state your name for the record?
Nicole Shepard.
Okay. And you're here to assist Mr. Salah. Is that correct?
That is correct.
All right. Is he unable to provide responses to my questions, or do you just need to give him some assistance if he can't answer my question?
To provide assistance. That is correct.
All right. So I would like him to try and first answer the question himself. So then if he needs some information or discussion with you before he provides his answer, then I will. Okay.
Thank you, sir.
So Mr. Salah, what are you requesting in general regarding your motion?
To have more time on the phone with my son
And for him to be able to come here.
so we have him to come down to Buffalo to see his father more.
So what he's, is he wants more full time with his son. The order hasn't been followed. It's when Ms. Hodge wants him to be on the phone. He would like more visitation time with his son. He's spent thousands of dollars going down there 2 times now. He has 8 days planned to go down in January. I think it'd be appropriate that it'd be a 50-50 thing to where she has to come to Buffalo. I understand she doesn't drive. There are planes, trains, and buses for her to get here to bring her son to see Daniel. And then during the visits for her not to be present.
All right, thank you. And Ms. Hodge, are you in agreement with these changes or disagreement?
Well, it's kind of hard for me to travel by myself because with my mental illness and I have to take care of my mom. I told Dan and Nicole that before.
Well,
and my husband
that the child makes some type of parenting time with Mr. Salah at his residence?
And sometimes I let Danny talk to his dad for almost an hour sometimes and let Dan talk to him early on some days.
All right, so he's requesting some time, some parenting time outside of Michigan at his residence. Are you in agreement with that or disagreement?
Well, like I said, that's kind of hard for me to do that.
I'm not asking it for you to do it. I'm just asking if you are in agreement to allow that to happen, and then they can then the two of you can discuss how that might happen if that's a possibility.
Your Honor, we're willing to do the transportation.
Ma'am, I didn't quite reach out to you yet. I'm not trying to have a conversation with Ms. Hodge, so I'd appreciate it if you do not interrupt me. Ms. Hodge, what are your thoughts on the child going to his residence for visitation?
I mean, I'm a little nervous still about it, about me and him going there.
All right, well, I mean, nervous is probably a natural reaction to that type of thing, but are you indicating you are opposed to it happening?
Maybe in the future, maybe.
All right, well, by the future, do you mean tomorrow, which is the future, or do you mean 6 months, 1 year, 2 years, 10 years?
Probably almost a year.
Okay. All right, so I'm guessing, Mr. Salah, you don't want to wait that long for in-person visitations?
No.
All right. And what we would do is we would set the matter for a hearing. Ms. Shepard, you indicated he's coming to Michigan in January. Is that correct?
Yes, Your Honor. So he's been down there in August for 4 days. We just got back on Monday evening. He was there for 4 days. And
my question was pretty simple. He's coming in January, correct? And do you know what dates he's coming in January?
yeah, he does. Give me 1 second. I'll give you the exact dates. I will pull up his reservation here. It is December 29th to January 6th.
Okay. I was just asking because we do have a date available in January for a hearing, but unfortunately it is the end of the month. So what the next step would be is we would have a evidentiary hearing. I typically require that those be in person, as doing full evidentiary hearings on Zoom is not always the greatest way to handle a case and have discussions and appropriate testimony. Is there any issue? So I have a date available on January 29th. Do you see any issue with Mr. Salah being here for that court date?
It'd be weather dependent because we're driving.
Okay. Well, what I'll do then is I'll set it for January 29th at 1 p.m.
Okay.
As an in-person hearing. So Ms. Hodge, you would be here in court also in person. Child is 8 years old, is that correct?
Yes.
All right. So Ms. Hodge, I would also do a meeting with the child before the court hearing. So the child would need to be here at 12:45 that day for a preference interview with me. That is not done in open court. That's just a brief conversation that I have with the child because the child has a right to express a preference.
Okay, what day?
January 29th. And you will get a copy of it.
All right, making sure.
January 29th. Child would be here at 12:45. Hearing would be at 1 p.m. Make sure someone is here to take the child back home or to school after the child's interview because the child cannot be in court during the court hearing.
Okay.
Until that time, the parties obviously need to continue to follow the terms of the current order. Any questions, Ms. Hodge?
No.
Okay. Mr. Salah, any questions?
No, Your Honor.
All right. Thank you both for appearing then. We'll see you back here on January 29th.
Thank you.
Yes.
Yes, sir.
All right, thank you. We do have parties present. So this is an initial hearing before the front of the court to see if there's any agreements on custody, parenting time, and support. Ms. Lockshire, you are the plaintiff, so I will ask you first. Do the two of you have any agreements on those issues?
Yes, sir, we do.
Okay, then what is your agreement?
Our agreement is the children will live with me in Michigan throughout the school year, and they will travel out to their father in California during the summer breaks.
Okay. And are the two of you sharing legal custody? Is legal custody going to be joint or sole?
Yes, we will split 50-50 legal custody.
Are there any agreements at this time as to how travel is going to occur, who's paying for it, or any of those kind of things, or is that just something the two of you will figure out?
I think we'll figure it out, but it sounds like he'll get them to him and I'll get them back to me.
Okay. And sir, does that sound like the agreement that you have?
Yes, sir, it does.
All right, Ms. Slopshire, would you please raise your right hand? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
Yes.
All right, thank you. You can put your hand down. And so, ma'am, is it correct that you're asking this court to enter an order that would grant the parties joint legal custody? You would have the primary physical custody because you would have the children throughout the school year, and then the children would be with dad in the summer. Is that correct?
Yes, sir, that's correct.
And as far as transportation for the summer, dad would be responsible for the cost for the children to get to California, and then you would be responsible for their return back to Michigan at the end. Is that correct?
Yes, sir.
And do you feel this agreement is in the best interest of the children?
I do.
Do you know approximately how much of the summer the children would be with dad?
I think it would come out probably to a little over 2 months, just for a week after school ends to a week or two before school starts.
Okay. Thank you. Sir, would you please raise your right hand? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
Yes, I do.
Thank you. And sir, are you also asking this court to enter an order that grants the parties joint legal custody, primary physical custody with Ms. Slopshire, and children to reside with her during the school year, and then to be with you in the summer?
Yes, sir.
And do you believe this agreement is in the best interest of the children?
Yes, I do.
All right. So the court will enter that order. The court will also prepare a child support recommendation based on the custody agreement. The parties will have the right to object to that recommendation if they are not in agreement with those terms. In front of the court, do you have the parties' information to prepare that order?
I do, however, Mr. Lopshire does still need to attend Smile.
All right, sir, so there is that SMILE class that you have to do. It is by Zoom, so you don't have to be in person, but you do need to have that completed before your case can be finalized. Do you understand?
Yes, sir. I'm scheduled for the 4th of December to attend.
Okay, excellent. Perfect. Any questions, Ms. Slopshire?
No, sir.
And Mr. Lopshire, any questions?
I have one, sir. On the document that we got from friend of the court for my monthly pay and salary, I accidentally put that $4,000 from rental income. It is supposed to be for allowance for rent because I am in the military. I do get basic allowance for housing. So I just put it in the wrong spot.
All right, thank you. Well, thank you for letting us know that. The two of you are all set. You will get a copy of the order from today, and then as I indicated, there will also be a support recommendation prepared.
Thank you.
Thank you. You're all set and can sign off.
Thank you.
The parties on that matter present.
Yes.
Yes.
All right, and Mr. Midget, this is your motion regarding parenting time. Is that correct?
Yes, sir.
And at this time, what type of parenting time are you requesting?
Visitation with Taylor, being able to call her and see her.
And Ms. Wiggs, what is your position at this time regarding parenting time?
I tried to come up with an agreement with Mr. Media. He didn't seem too fond of the agreement. Mr. Media has been incarcerated for 7 years out of her life, in and out of jail, has a history of drug and violence. And I had asked him if we could do every other weekend supervised visits, no overnights, for 3 months, so until he shows consistency and shows that he will not go back to jail. And then I would do every other weekend, and he could have her for Father's Day and one day after every holiday. But he seems to want to be with her every day, which is like understandable. Yes, it's his daughter and he loves her, but there's also reasons why I don't feel overnights is okay.
All right, and Mr. Bidget, you are not in agreement with that parenting time?
That is not true. I did agree to it, but I said I was still going to court because I wanted something in writing. And the agreement was supposed to be 3 weekends a month, every day after the holiday and on Father's Day.
All right. Ms. Wiggs, does that sound accurate?
It was. I did tell him 3 weekends a month until he blew up my phone with messages upon messages telling me I need to answer every single time he calls. And
okay. No problem. If we don't have an agreement, that's fine. We'll give you guys a hearing date instead. Okay. If the two of you reach an agreement prior to your hearing date, that's fine. You can certainly come to an agreement still. But what we do is set the matter for a hearing. I got to decide if you guys need an hour or 3 hours of time for a hearing. So, Ms. Wiggs, do you intend to call any witnesses or just provide your own testimony at a hearing?
My own testimony is good enough.
All right. Mr. Midget, do you intend to call any witnesses or just testify yourself?
Yes.
Yes, which one?
Dennis Midget, my dad, Taylor's grandfather.
Okay. Any other witnesses?
No, sir.
All right. Well, then I think we could likely complete it in an hour of time. So the next time the court has available for an evidentiary hearing is January 29th at 11 a.m. Do either of you have any conflict with that date?
I do not.
No, sir.
And the child is 9 years old, is that correct?
He is, yes.
All right, so there would be a child preference interview, which is required.
Okay.
So I would meet with the child for a child preference interview 15 minutes before the hearing, so the child should be here at 10:45 that day. And then someone should be here to be able to take the child back to school or home. This would be an in-person hearing, so both of you are required to be here in person for that hearing on the 29th. You'll get a copy of that notice. Mr. Midget, do you have any issue providing your current address, or would you like to contact the friend of the court by phone and do that?
I do not.
All right, what is your current address?
286.
All right, so I would order the front of the court to update that. Front of the court, is there any other information you need from the parties?
As far as doing a child support recommendation, which will be needed, I do need the plaintiff's information. If she doesn't have it, I can resend it.
All right, Ms. Wiggs, did you get that questionnaire regarding financial information?
I didn't. Could you resend it, please?
All right, we will resend that. Obviously, once there's an order in place, there will be a child support recommendation that is prepared.
All right.
All right, we will see you both back here then on the 29th of January. And like I said, the two of you can continue to talk. And if you reach some type of agreement, we can simply put that agreement on the record that day. And if you don't have an agreement, then we'll just have a hearing, okay?
Okay, thank you.
Thank you.
5-1. All right, thank you. Do you have the parties on that matter present?
Yes.
I'm here.
Thank you. We do have both parties present. And Ms. Fritz, you have filed a motion regarding custody, is that correct?
That is correct.
And ma'am, what are you seeking to do with your motion?
I am looking to get 50-50 custody, just split right down the middle, and we currently share joint legal. I'm looking to keep that the same.
Okay. Mr. Cotter, do you have a motion too or not?
Yeah, I originally filed the motion, and then I think she maybe filed one as well later on. So It sounds like we both filed, and we have two separate court dates for the same thing.
Prior to the cancellation of the last hearing.
Okay. Okay, I see that. All right, so your Ms. Britz's motion is set for December, and yours is set for today. So what are you seeking to do?
Well, at this point, I want to set up. My overall goal is to create a safe environment and healthy environment for Olivia to spend time with her mother and have that bond that she needs with her. But right now, with Shannon's current situation and her decisions, I don't believe it's the best choice for Olivia to be in that environment. And so until she can change that, I feel either A, she's going to have to be in some sort of supervised environment to create a security safety net for Olivia, so she knows she won't be put in this environment again. I know that
in my actual motion, I didn't want certain people present, and I have my reasons.
All right, then what we would do is set the matter for a hearing. Mr. Goddard, do you intend to call witnesses or just provide your own testimony?
I do plan to call witnesses. I don't know all of them, but I do have at least 2 that I would be calling.
Okay, and Ms. Fritz, do you intend to call witnesses or just provide your own testimony?
I do also intend to call witnesses, and I have 3 I would be providing.
All right, then I'll give the 2 of you the longer time slot of 3 hours. The next 3-hour slots that we have available, February 10th is the first availability. Do either of you have any conflict with that date?
I do not.
I wouldn't be able to tell you up front if I do or don't. I'm sorry.
You don't know, sir?
Yeah, I wouldn't know off the top of my head. I don't know.
All right.
I'll make sure to make time for those, so February 10th works for me.
Do you intend to be out of the state for anything in February, Mr. Goddard?
But I mean, potentially, there's occasions that my employer will require me to be out. But if you want to do it on February 10th, I can make it happen.
All right, that should be enough advance notice that you can make sure that you're available that day. So we'll set it for February 10th at 9 a.m. Given the child's age, I will meet with the child for a preference interview at 8:45. So there should be arrangements so the child could be taken, back to school or back home after that interview, rather than being here at the courthouse while that hearing is going on. You will get a copy of this hearing notice, of course, but we'll see you back. That's an in-person hearing, so we are here in the courtroom.
Your Honor.
Yes.
Will we then adjourn hers to that date as well?
Yes. So yeah, Ms. Briggs has that court date currently set for the 18th. That we don't need to worry about. We're taking care of that now. So we'll hear both motions on February 10th at 9 a.m. There's no need for either one of you to appear on that December 18th date. Okay?
Okay.
Any questions, Mr. Goddard?
No, I'm clear on everything. Thank you.
Thank you, Ms. Briggs. Any questions?
Yeah, while we are in the interim, because I actually filed a violation against Andrew. I have not seen my daughter since July 12th, and unfortunately, I was unaware that I was supposed to show up for him answering for my violation, which I talked to my caseworker about. And then after the fact is when I filed my custody paperwork. I've tried to send her several text messages. I ran into her once at one of the football games, one of my other daughters cheers in it, and she happened to be there. I've had no communication with her, and honestly, this is super hard for me. I'm just wondering, because of what the current custody order is, do I just have to wait until February to see and talk to her?
Well, the order is what is in place. So if it's not being followed, that certainly would be an issue at any potential, or would be an issue at a hearing if somebody's not following an order. That's part of potentially one of the best interest factors, as well as can be an issue as far as any decision the court makes if a party is not following an order without justification. So what's in place is what your last order is. I can't make any changes to that until I have a full evidentiary hearing.
Okay, thank you.
All right. Thank you both for appearing. I'll see you back here on February 10th.
Thank you.
Thank you.
Hello, can you hear me?
Yes, ma'am. We're just waiting for the other side to sign in.
Okay, I'm still kind of new to Zoom. I haven't really used it much, so I was just making sure you can hear me, sir.
Yep, no problem. All right, the court will call the matter then of Christy Wheeler versus Cody Frost. We do have Miss Wheeler present. I do not see Mr. Frost present. This was scheduled to potentially place an agreement on the record. The parties, or Mr. Frost previously filed a motion regarding parenting time. The parties were referred to mediation. Miss Wheeler, did the two of you reach any agreement?
Yes, we came to an agreement around the time that this court date was came, and this last week, me and him have been kind of had a bumpy road. I have been providing transportation like he asked, I have been using my own money to go and drop him off and pick him up most days. I've been letting him spend weekends with him, Friday, Saturday, and Sunday, and everything was fine. And recently, I called my child support, and I have not had a balance. I have had a balance of $1 since October 25th. And my last payment was $87.42 on October 25th. And he got kind of rude with me and said that he paid. And I said, okay. And I said, I'll wait for the payment. And I never got it. And that honestly is a problem because I am part-time at TJ Maxx, and I feel if he wants to come to these agreements, he needs to at least pay me my minimum. And I've been only getting $80 a month. And as a single mother, that's very hard. And I have been really trying to come to agreement.
This is his motion. So this is his motion regarding parenting time. He's not here, so typically what I'll do is if somebody doesn't appear for their own motion is I will dismiss the motion. But if you want me to adjourn this and you guys can continue to have discussions and have a new date, I would do that if that's your request. Otherwise, I would simply dismiss his motion since he failed to appear.
Sorry, I didn't mean to. I don't mean to be emotional. I'm sorry. I have been trying, and he just recently got into a place, and he was living with this woman, and it wasn't even my son didn't feel very comfortable at this other place. So now he has a new place, and I told him, I think last week, because I had him for last weekend because of his whole moving situations, and he just got a new place. So, and I told him I don't feel comfortable my son being there until he has a steady home, and I have not checked it out. So as of right now, I don't feel very comfortable until he at least pays me at least what I'm supposed to be paid, because I'm coming to his agreements of helping him with child support when, Your Honor, he doesn't even have a driver's license or a car.
Okay. All right, what I'm going to do is, given his failure to appear, I'm going to dismiss his motion. So the order that was in place previously is what remains. It's parenting time as agreed.
Okay.
As agreed, the two of us are certainly still free to reach some type of agreement and submit that if you want a court-ordered agreement. But at this time, that's what the order remains, is what that prior agreement was, is parenting time as the parties agreed. Okay?
That sounds wonderful. We'll make a new one with no changes. That sounds wonderful, Your Honor. Thank you.
All right, thank you for appearing. You are all set and can sign off.
Okay. Have a great day, sir.